Good evening, Judge Mocumie.
Good evening, Chief Justice. Good evening, Ntatele Bomme, Commissioners.
You have been a judge for how many years now? The High Court judge?
If I start from May 2005 when I acted in the Northern Cape, it's 10 and some few months.
And
But if I start from the 3rd of March 2008 when the then president appointed me, it's 8 and some few months.
yes. And you acted, is it correct, for about 12 months in the Supreme Court at the Supreme Court of Appeal?
Yes, from the 1st of December 2013 until November 2014.
And for another 12 months at the Competition Appeal Court?
That is correct, Chief Justice. The minister just extended my acting appointment in the CAC until next year, April.
Yes. Now let's go back to the Supreme Court of Appeal.
Yes.
Are you comfortable there? Have you settled in, or do you think you are not quite settled?
I'm definitely settled, Chief Justice.
That's why you have applied.
Yes.
Yes. Anything you want to tell us in your own words about your suitability for appointment compared to other candidates, without referring to them necessarily?
All right. CJ, you and commissioners, you would have noticed that I started my career in August 1988, the 15th to be precise. I have been there for 27 years now. I moved through probably all courts in South Africa, the Magistrate Court, Regional Court, High Court, and then I acted in the SCA, acted in the CAC, acted in the LAC as well. I have done quite a lot of work. I've been consistent in my work. I have performed in terms of the assignments that I have been allocated by all judge presidents that I worked with. You would have seen, CJ, that I did not only confine myself to the courtrooms, I participated in other structures outside the judiciary, so to speak, to continue educating our people on their rights, on what it means to be a South African citizen in a new democracy. I participated even in different legal organizations, continuing the work that I started even before I became a prosecutor or a legal assistant back then. I believe, having acted in the Supreme Court of Appeal for that time that you have mentioned, CJ, has equipped me sufficiently to be appointed permanently to this SCA. In addition to having acted in the SCA, as you correctly noted, having acted in the CAC also gave me added value, so to speak. What matters come before the Competition Appeal Court don't ordinarily come to the High Courts. And I think the experience that I got there can add more value to the Supreme Court of Appeal. I'm aware that there are judges who have been recently appointed who also sit on the CAC, but more people, more means diversity in thinking, in developing the jurisprudence of that court. As I said, acting in the Labour Appeal Court also strengthened me. The matters that would come to the SCA, not necessarily through the ordinary channels of the Labour Court, do come to the SCA, and I would be able to contribute immensely on the jurisprudence in that aspect. I may also add, CJ, I sit on the Hague Convention, what we call the International Network of Judges. It's a big body. You would know South Africa is a signatory to the Hague Convention. And on that body sits different representatives from different countries. I attended a meeting recently, in May 2015, and on that particular expert group, I was the only African representative. I interacted with very senior judicial officers of the appeal courts from different countries, Russia, Yugoslavia, and I could manage to hold my head up high and contribute to the best of my ability, as I know South Africans are capable of. I am certain that the experience that I gained in the magistracy court, in the magistracy, cannot go away. I bring that to the SCA. Generally, we don't have people who rose through the ranks like I did, from legal assistant, prosecutor, magistrate, regional magistrate, acting judge, a permanent judge. I think there's no way that the experience that I got throughout my progression cannot rub off in the Supreme Court of Appeal. And I'm certain that is what would distinguish me from the rest of others. I don't remember them acting in the Competition Appeal Court. I don't remember them acting in the Labor Appeal Court.
Thank you, Judge Mocumie. President Patti?
Thank you, Chief Justice. Good evening, Judge
Good evening,
Mocumie.
Judge Mpati.
A colleague in the SCA said to me, your surname should be pronounced Mocumie. Is it Mocumie or Mocumie?
Mocumie.
Mocumie.
Mocumie. Pure Tswana.
Mocumie.
Yes.
Okay. Tell me, how often does the Competition Appeal Court sit in a year?
4 times.
4 times, and how long are the sessions?
4 hours, 2 4-hours.
No, for instance, does it sit for a week continuously doing various matters, or does it sit for only so many days in a week?
It says for so many days in a week.
Which is usually how many days in a week?
2 days.
And of course, you acted in the Labor Appeal Court before you came to the SCA.
Yes.
Yes. And you spent a year in the SCA, or
Yes.
4
yes,
terms, that is.
Yes.
You were appointed acting judge for 6 months, and then it was extended for a further 6 months.
Yes. Yes. Mpati.
Yes. And how did you find the SCA? Answering that question, what was your relationship with other colleagues in the
Yes.
SCA?
It was intimidating. First, before I went there. But upon our arrival, I think we were 4, 3 men and me as the only woman then. Myself, Rami Matopu, who's appointed now, Rel Khodi, and Van Zyl from the Eastern Cape. You invited us to your chambers and welcomed us, explained to us the unwritten little rules that can make one do stupid things, so to speak. You explained to us that, you know, the atmosphere might not look pleasant because people are never seen in the corridors, but their doors are always open. And we took your advice. From there, it was quite easy. The first few weeks, months were a bit hectic, of course, without you knowing, you know, how to match up to the standard, the high standard there. But through your guidance, number of judgments that we set in, I became confident every time that I came back from court. And I took back that confidence that I lacked a day or 2 or a week probably when I started acting. So it was a pleasant stay for me there. Colleagues were collegial. Anyone that I sat with, I could knock on his or her door and talk about the judgment that we were to write together. The tea room was much pleasant. Go there, the Wednesdays, lunch for everybody. And it was quite surprisingly pleasant. As I indicated, the impression out there is that it's not as pleasant as one can experience it.
Just in case people might think that lunch comes from some coffers, we fork out money for those.
We
for
do.
Those, is that correct?
We do. Yes.
All right. In respect of, let me first start with an issue that was raised. Your experience sitting in court in the SCA, have you ever felt that counsel was not given sufficient time and opportunity to present their case?
Not at all. Not at all. What?
Don't ask me what was said just now.
No.
In respect of judgments that were allocated to you, is there an occasion where your judgment was wholly accepted, or were all your judgments worked on, changed, suggestions made, and so forth?
The one specific judgment that comes to mind is the one that we did together. The Minister of Police versus Metal something. It's in here. That's one of the judgment that I quoted, where we both wrote the judgment. I started with the judgment, but like we do in the Supreme Court of Appeal, you circulate the first draft to colleagues. Colleagues makes comments, add here and there, but where at some point it reaches one colleague and that colleague makes extensive contribution, you say, no, there was extensive contribution. You don't want to own this judgment. And we did that together. And but not wholly. I do appreciate the guidance there. At least when I read it, there are lines that I recognize are mine. The kind of English that says it's me. And I was grateful for the guidance that you gave me. There was another instance where I sat with other colleagues where we differed in terms of style. How I wrote evidently was not the standard expected of an acting judge in the Supreme Court of Appeal. We differed with the colleague in question, but I insisted that, look, even if we differ, allow me to continue writing this judgment. And I continued writing the judgment, and the judgment was ultimately accepted by all other colleagues. It's the same one that I added to the questionnaire, ESCOM versus Norton. And as they say, the rest is history.
Okay, I'm going to ask you about something that I don't believe you mentioned to me in confidence. When you finished your stint in the SCA in November of 2014?
14,
yeah.
yes.
2014, you mentioned to me that you think that you need more experience, you weren't ready for the SCA yet. Am I correct?
2014, yes.
And the only further experience that you now have, because you didn't act again in the SCA, although you said the experience that you got from the SCA makes you believe that you are ready for the SCA. That's not how
Yes.
I remember it. I think you said to me that I'm not ready yet for the SCA. So the only thing that could have made you ready now is your stint in the Competition Appeal Court. Am I not right?
No,
Insofar as appeals are concerned.
not necessarily. Yes and no.
Explain that.
I'll do that. I learned the other way that I shouldn't talk too much, so I'm trying to be precise. In that empathy, I want to believe that sitting as a full bench in the High Court, particularly on a judgment from one judge, we are three. And in the SCA, it's +2. And I'm not saying the work of the SCA is exactly the same as the High Court, but I'm saying once I came back from the SCA, I could appreciate better what is required at appeal level. So what I gained at the SCA, I then put into practice at the High Court. My judgment at appeal level improved tremendously. I wrote and co-wrote a judgment in the Competition Appeal Court. I have been invited again to act in the Competition Appeal Court. To me, that is an indication that I am capable of managing the work and that goes around in the SCA.
Sorry. So in actual fact, it is not correct for you to say your stint in the SCA made you ready for the SCA. It's further experience that you gained thereafter, if I understand you correctly.
Come again, Dad.
And so it is not that the SCA made you ready, your acting stint in the SCA made you ready for the SCA, because to me you said you're not ready. It must be further experience that you gained thereafter that made you ready for the SCA.
No, it's a bit of an unfair question in this context. You see, when you ask me something and I speak to you at a personal level, I say, yeah, I don't think I'm ready. But when I reflect, as I'm reflecting now, because I did not anticipate this kind of question, I then have to look at what is it that actually makes me say I am ready. Apart from the fact that I know for a fact that I am ready, I then have to say it's this and this and this and a conglomeration of all that that makes me say I am ready. Had I gone back to the SCA again, having been invited, I might have shown more of what I was capable of. But I am saying even now, I am ready.
You know, when I thought back to the time that you finished at the SCA and said you're not ready yet, you came to the JSC for the appointment. If you think it's an unfair question, you must tell me that it's unfair.
I will indicate.
You came to the Judicial Service Commission for a position as Judge President of the Free State, and another candidate was appointed. Isn't that the reason why you now want, or now say you are ready
No,
for the
not,
SCA?
not at all. Not at all. Not at all.
Thank you, Chief Justice.
Thank you, President Patti. Commissioners, any questions? Commissioner Modise?
Thank you, CJ. In your opinion, what are the obstacles to justice in South Africa? That will be my first. My second question would be this one. Over the last few years, various commentators have actually made remarks that the judicial system is being abused either by people who are in power or those who are aspiring to be in power to further whatever it is that they want to further. What is your opinion on that?
Very broad. I don't think people aspire to do anything of that sort. I would think that the judiciary is one arm of government, separate from the others. The importance thereof is that it can hold the others accountable to the extent where they transgress any law. But in the same breath, it also restrains itself from usurping the powers of other branches. The first question, Ustand, if you can repeat it.
Thank you, CJ. It was, what, in your view, are the obstacles to justice in South Africa?
Okay. Mostly it's money. People who do not have money generally don't have the muscle to go up to the Constitutional Court, for instance. It almost seems as if the law is meant for rich people, which we need to seriously take into consideration whenever we deliver our judgments, or we have to make judgments within reasonable time, not forgetting that for those people, if they were in court for one day, it might cost them their jobs to come back to court. It's a conglomeration of different issues, but mostly it's about lack of financial means to access courts.
Thank you, sir. Before 1994, Parliament was said to be supreme. And the laws made by that Parliament could really never be challenged. And therefore, I think that what the courts mostly did was to interpret and try and understand where the legislators were coming from. So today, things are a little bit different. So in your thinking, what is the difference between that period and this period we are in, where now it is the Constitution which is said to be supreme?
If we take, for example, the death penalty, that was part of the previous dispensation. That particular policy could not be questioned by any judge, presiding officer in South Africa. Few judges back then dared go otherwise or different from the facts that were presented. But post-94, we have a democracy, We have a constitution that outlines values that direct us as a society. And death penalty is not part of our dispensation now. It has been declared unconstitutional. There are other instances that say to us we can independently declare any law inconsistent with the Constitution. And to that extent, say to the legislature, re-look at this particular law, it's inconsistent with the Constitution, and correct it to the best of your ability. It is then to the legislature to do that, go back to the drawing board and correct that if it believes that it is really inconsistent with the Constitution. So the difference is that previously people or the judiciary adhered to the law, doing just as the statute dictated, but now the values underpinning the Constitution, our history as a country, come in to say to us as judicial officers, you cannot treat an individual, for instance, in this particular way. The Bill of Rights sets out how individuals should be treated, and we respect that.
Ho leboga rona, Commissioner. Commissioner Ntsebeza?
Yeah, thank you, Chief Justice. I see that you claim proficiency in 6 languages,
Yes.
and quite apart from English and Afrikaans, you are proficient in Setswana, Sesotho, isiZulu, and isiXhosa. Now,
Two. Okay.
yes. In what way does that assist you in your duties as a judge?
In court, for instance, if I sit in Harrismith on circuit court, there's usually a mixture of languages, and our interpretation in the country is not so perfect. Now, because of my knowing the different languages, it assists me to say, but that is not what I heard the witness saying. Can you allow the witness to repeat what he or she said? Nicely saying to the interpreter, you are not interpreting properly. So it comes in handy during areas of such nature.
Is your proficiency in Afrikaans such that you would be able to deal with a complete record as an appellate judge if it was in Afrikaans?
I do that. I do that in the High Court, Free State, predominantly Afrikaans-speaking people. I did that in the Northern Cape when I was acting there. And I come from the Northern Cape. It's my, I think, my second language. Yeah.
In the SCA, have you been put in a panel where the record was in Afrikaans?
Not at all.
But if you were, you would be competent to deal with it.
I'll definitely be competent to deal with it.
Thank you, Chief Justice.
Thank you, Commissioner Ntsebeza. Commissioner Siminyao?
Chief Justice, thank you. Judge, good evening.
Good evening, Dati.
The Supreme Court of Appeal looks askance at counsel who would cite more than one authority which makes the same proposition.
Yes.
The Constitutional Court, on the other hand, will cite everything that it has said in the past since Makwanyana.
Yes.
Where should the balance be struck there.
Yeah, it's a complicated one. But I think both read well. The SEA is to the point. They don't repeat like you correctly point out. The Concord just loves repeating itself.
We will examine your judgments properly on appeal.
That's undiplomatic.
No, thank you, thank you.
Commissioner Fori?
Thank you, Chief Justice. Good evening, Judge Mocumie.
Good evening, Dr.
You made the statement that the law seems to be for the rich.
Yes.
Now, we know that vast amounts of monies are spent on legal aid. The law societies have made pro bono service by attorneys compulsory. That, if you make that statement, doesn't seem to be enough. What, from a practical point of view, can you put forward as a solution to what you perceive the law to be for the rich only? What can be done, if you are correct, to alleviate that or even eradicate that completely?
Right. I think the kind of service people get from Legal Aid Board, Legal Aid South Africa, is not on the same level as that which you get from private practitioners. Most of the time, those that come into the legal aid just stay for a while and then go leave the system just when they have gained enough experience to appear in the high courts, for instance. The Legal Aid Board then lose those type of skilled people. I think there should be more investment in institutions of that nature for people to gain confidence, one, in the system, in the legal aid system, as well as for members of society to also see from the example that the legal aid members set that they can trust them to deal with their matters to finality. The difference that you see every day in court between these two systems is palpable. So I think more investment should be put into the institutions of government that are there to give, are supposed to give service to poor people that cannot afford expensive counsel as rich people can.
So do I understand you correctly to say that you think the standard of legal aid should be improved?
Yes.
I think that implies much more money.
Yes.
And you say that that should be made available to achieve that goal.
Look, not necessarily now under the circumstances that we are financially as a country, but it's a long-term investment that will also say to people they can stay in legal aid instead of going somewhere else. If their salaries can be upped a little bit, just for them to be able to afford a car, afford this, that kind of, just to make it attractive for them to stay on instead of going to private practice.
On a lighter note, in my book of different languages, you've said you're from the Northern Cape, but not where. So I'm going to ask you the question in Setswana. Otswa Kai. whatever that means.
Deputy Minister.
Thank you very much, Chief Justice, and good evening, Judge.
Good evening, that.
What is the view on cases being televised live, the proceedings being televised live, the effect on the witnesses, the accused, even the potential influence on the judges, because you find that in some instances there are legal analysts that are analyzing the case as it is proceeding. So what are your views on that?
Look, we are in a democratic country. The media and like all other institutions have certain rights as well. We fought hard for rights of journalists to write and give their opinion on matters that have an effect on society in general. To that extent, I think that kind of exposure is necessary to inform members of the society what is happening in the court to a limited extent. The way it was done in Oscar Pistorius' matter was too intrusive for me. It made everybody comment on what was happening every day. I think like I say, it was more intrusive. There could have been limitations on when and how to do that. But as I'm saying, the right of journalists to inform the public that is entitled to know what is happening also has to be taken into account. So every day that we do it, it's done every time, but the particular judge will say, under these circumstances, in this particular instance, and conditions for publication.
Thank you, Deputy Minister. Commissioner Ntlama. Thank you. Commissioner Komo.
Judge Mocumie, Judge Mocumie, only on one aspect.
And
You spoke of the question that the courts seem to be more accessible to the rich, but I wonder whether you have lost sight of the fact that bodies like NADEL and BLA represented people for free, and of course there is also the Legal Resources Center and other bodies. But in particular, from 1992, we served together in NADEL until I was appointed a judge. Did you not think that bringing out such aspect would assist the poor and the indigent in addition to the legal aid bond?
It's correct. My answer had to do with what hits you in the face every day in South Africa. I think what we do in NADEL, in BLA, in the International Association of Women Judges, South African Women Lawyers Association, and all other organizations, including NGOs, is to educate, to assist to the extent that we can. But what we see happening in courts is more in your face that, but if this case is dealt in this fashion, it's even publicized internationally, but then next door there's another case, nothing is said about it. That is the impression that I have a problem with. It's true those organizations do a lot, but it is maybe not shown that they are doing something more. But like I say, the impression is exactly that.
Yes, thank you, Chief Justice.
Thank you. Commissioner Nokesi?
Thank you, Chief Justice. Literally one question. You make as a factual statement, that's what worries me, the fact that the kind of legal services from the legal aid is different from the private practice.
Yes.
What are the basis for that?
I'm a judge in the High Court. I was a magistrate for a long time. I was a prosecutor for a long time. I experienced it.
Secondly, you say... No, secondly on this, is just on this, sorry, on this.
That's a door stopper.
On this, you again suggest that the incentives from legal aid comparable from other firms is lower.
Yes.
Where do you get that?
Experience.
Okay. Now, I'm asking you this question. I'm sitting there in the legal aid board. This is not correct.
It is.
It's
We
factually
can.
not correct, but
No.
we cannot argue about that. I can
We
even
can-
show statistics, and also in terms of benchmarking with the NDPP and other institutions.
Yeah.
This is factual.
Now, Commissioner, you are testifying now.
Yes, yeah.
Commissioner Malema?
No, I wanted to rise on a point of order because we're asking her questions, she gives her opinion, and it doesn't matter what we think. On the basis of her opinion, we'll then remain here and make our own reflections. So we must not impose ourselves on her. And I entirely agree with her. The quality, we'll engage.
You see, Commissioner, it is his first day. And there's a lot of energy, so please. You are excused. I thought I was going to challenge you about the nature of constitutional court judgments, but you are excused.
Thank you. Thank you.